first time I'm doing this in front of a large group anyway. I've done it privately before, smaller groups. And you can see I'm wearing a dark suit because of that old joke about why do you work hard around here? Well, you get a nice warm feeling that nobody notices. So in case I get a little bit of an accent, no one's going to notice. So metal streaming, we're supposed to get some pictures along with this presentation, and it's hard to get a picture for metal streaming. It's a picture of Goldstream Provincial Park. It's just outside of Victoria. Really nothing to do with metal streaming other than the name Goldstream. But it's a very pretty picture. Okay, so this is just a high-level view of what metal streaming is all about. It's a form of financing, and there's a few out there now, right? The producer, the company that gets the financing, gets upfront cash and gets an ongoing small stream of predetermined payments, like a bit of a recovery of cost. The vendor receives future production of metal. So you basically give up, say, 7% of your mine or whatever it is over the life of the mine, right? And then so how do you account for it? Well, the specific terms of the agreement really have a big impact on how it's accounted for by the producer. This is what we're talking about here. I mean, these are started by Silver Wheaton and you know, now the next one goes into Sandstorm, and some of them are getting syndicated by Franco-Nevada. And of course, what all of that has in common is Nolan Watson. So, and Steve will correct me if I'm wrong, if I get any of this wrong, but I'm going at a high level. He's the Luna Gold went through some of these hoops to get this accounted for. So there's three ways a producer can account for the streaming arrangement, right? Three common ways, and then there's even within this you can do a combination of them all, right? First one generally is a commodity arrangement. You know, the bad word derivative. So because you're required to give up product, you might have to reprice the arrangement, the $40 million you get, you know, based on fair value at every single year or every single quarter. That's a tough one. There's an out of it. You can have this own use exemption that seems to get you out of it. And depending on which firm you've talked with, the own use exemption may or may not apply. But basically, the big ones are a derivative, a financial liability, which is a debt commonly referred to as deferred revenue on the balance sheet. And then the third one is basically a sale of part of your mineral interest, right? And then you can have a combination of them both. I mean, Luna went through the example where it was originally accounted for as a deferred revenue being amortized when they took production out of the ground. Subsequently, when they met their minimum targets, you know, it was they accounted for it as part of a sale of a mineral interest plus a derivative liability and the rest of it, right? Sound about right, Steve? And you know, typically what I've seen, and the few that I have seen, that what you do is once you raise the financing and everyone finishes celebrating, then you have to account for it. Well, it's a complicated thing, right? So very small nuances will have a big impact on the agreement. So typically what will happen is you'll get some sort of other accounting firm, a Big Four, you know, whoever it is, Steve's firm, to give you an assessment of what the accounting might be, right? To give a report to the management and to the board. And then it's the auditors have to take a look at it and say, well, you know, critique it and find out what they think about it, and God forbid that these two bodies disagree, right? Because then you're refereeing a fight amongst professionals. But you know, when I was talking to Nolan, he was saying that, well, why don't they just ask us? You know, because they have to account for the thing on the other side. So you know, and they're the ones that put the thing together. So get some advice from them of how they account for it on the other side, and maybe they can give you enough ammunition to present your argument more effectively. Next topic. I'm not going to ask for questions now because there's endless questions with that. But next topic, Corruption of Foreign Public Officials Act. So again, another picture. Minister, could you comment on the suspicion of epidemic corruption in the EU? He said, yes, I could, but it'll cost you. So there's one in the States this one's referred to as the Canadian equivalent of the U.S. Foreign Corrupt Practices Act, right? It's getting a little bit more press. So here's the rule right here. This is every person commits an offense who, in order to obtain or retain advantage in the course of business, directly or indirectly gives, offers, or agrees, very legalese, a reward, advantage, or benefit of any kind to a foreign public official. as consideration for an act or omission by the official or to induce the official to use his or position to influence. Right? That's the law, right? Now, if you break this law, you can get, used to you up to 5 years in prison and an unlimited fine. They raised that, I think it was in June of 2014, maybe 13, to 14 years in prison and still an unlimited fine. Okay, so who's been convicted? Well, there's some old ones and there's a brand new one that's coming up too. You may have heard of it. So Griffiths Energy International. These are old. These are from 7, 8, and 2009, that kind of stuff. But you'll see a common theme in this. Griffin, based in Calgary, pleaded guilty in 2013 to a charge under the act relating to securities act. In Chad, Griffiths will pay a total penalty of $10.3 million. They're bribing people, right? Here's another one of the convictions in the past. Nico Resources, based in Calgary, Alberta. The company provided the use of a vehicle. It doesn't sound like that much, right? Provided the use of a vehicle, paid some travel expenses, for a minister to travel from New York to Chicago. As a result of the conviction, though, Nico was fined $9.5 million and placed on a probation order, right? So, and then there's one more that actually is convicted, and it's Hydro Clean Energy. And these guys, again, based out of Red Deer, Alberta, I'm not lying, entered into a guilty plea to one count of bribery, was ordered to pay a fine of $25. These guys were bribing a U.S. immigration officer who worked in the Calgary International Airport. Okay, and then there's one more I learned up here. And this is a more recent one. There's guys that have been charged but not convicted. And this is a guy named Carragher and Cryptometrics Canada. Seems self-evident, but apparently Cryptometrics was making a request for proposal for Air India, and they were using this gentleman Craigar, and I used to say alleged, but he's been convicted, as an agent. They viewed him as an agent, and he basically supplied the company with a list of people to bribe. So they sent him some money, and then they don't know what happened with the money, but Craigar eventually got convicted, and they're going after others now too, like U.S. officials, that kind of stuff. Canada doesn't want to be viewed as light, and the U.S. is Canada was given not as a soft kind of assessment of foreign corrupt practices, so they had to beef it up. So there's going to be more evolution of charges on this. So what can you do? Why does it affect you guys? Well, the problem is the onus is on self-regulation, and monitoring is on the companies. So you have to do it yourself. So what do? Well, establish and monitor a compliance program. That's what the suggestion is, right? So you communicate a corporate policy, like whistleblowing, communicate a corporate policy, demonstrate tone at the top, and assign some executive to take care of this, right? So you have a meeting, the guy who wasn't there, poor slob, he gets assigned to be the head of the corporate responsibility here thing. Conduct a periodic review. And so I'll say now, I should have said before, these views are my own, not necessarily the views of Davidson Company or anybody else, but and we're not working for CRA, we're not working for any other regulators, but here's one of the things that we're encouraged to do now we're going to end up doing is when you have an operation in a foreign jurisdiction, just take a look through your expenditures, kind of do a test, what was this $50,000 payment over to a consultant over in Chad or Angola, what was that for, right? And so I suppose when you carry that further, well, sorry, Mr. Maloff, it was for a consulting agreement. Well, okay, that's fine. If it's the worst that we can do is report to the audit committee. That's it. But in this case, you have to have a compliance program to make sure that you're not doing it, or investigations can happen. Right? Next topic. Corporate social responsibility. Oh, and there's a viewpoint on this, and there's a viewpoint on the streaming too. I don't know, Steve, if you saw that one before, but yeah, it's Nolan Watson did enough of these that I guess the CICA, PDAC came out with a viewpoint on the topic, right? And there's another one on corporate social responsibility. It's a fairly hot topic lately. These two pictures are from, one of them's a video, one from Kinross and Yamana's corporate social responsibility reports. Okay, so the deal with corporate social responsibility is it might end up being a provision. So it's just the same same rules as any provision. It's presented as an obligation as a result of a past event, probability that resources will be required to settle the obligation, and a reasonable estimate can be made. So the killer is that the obligation can be legal or constructive. A legal obligation is easy to find. I mean, in your concession arrangement or some sort of contract, you have to build a hospital, you know. But the constructive obligation, that's the part that's a little bit more difficult or more judgmental, right? So we'll go into a couple of examples, and these are from the viewpoint as well. So example A, you know, the budget's approved by the board to build a hospital, and then the commitment to construct the hospital is outlined in the concession and signed by the host community. Sounds pretty self-evident, doesn't it, right? So you should record a provision. I mean, you have a legal obligation because there's a concession it's signed by it's in the concession, right? And then you agree to do it because it's approved by the budget. So what's the other side? You record a liability. On the other side could be capitalization if it meets it under IFRS 6 or IAS 16, or as a cost to develop the mine. You know, those are some possibilities there, right? And then another example is, this is more of constructive obligation. Company commits to build a local hospital and budget's approved by the board. The obligation is not specifically listed in the concession with the community, so it's not a legal obligation. So you need to consider if a constructive obligation exists, right? So some things you consider. Well, you know, board approval, date the community's informed, and this is the one, past history of executing on these obligations, right? So when you got a guy running around, this local country manager, and he's promising to do stuff with the locals, does that end up being a constructive obligation? I don't know. Again, this is my opinion, but possibly, but you have to have a history of following through on these constructive obligations before you actually have probably a real obligation. And the guy will probably get you more in trouble with locals just by not following through what he promises, and all of a sudden you get troubles with the locals. All right, that's it, guys.